Thank you, Mr. President. The substitute to House Bill 87 is the Senate version of House Bill 87. We did make some changes to the legislation, and we have been working with the author, Representative Ramsey, in the House, and we are doing our best to incorporate suggestions into the bill. So I'm just going to we tried to give it a good legal look in Senate Judiciary, and I'm coming at it kind of from that perspective to give you my best legal description of what the bill does. And I'll try to run through it very quickly since we're going late this evening. But the first several sections through Section 3 amend current law. As you are aware, several years ago we passed legislation that required public works contractors to use E-Verify to verify that their employees are authorized to work when they entered into a contract with a public agency. And we are further defining the entities that are involved in that process, clearing up the language in terms of the definition of a subcontractor and a subcontractor. Oftentimes, general contractors will have several subs down the line, and we just want to make sure that the law provides that all of the subcontractors, including the subcontractors, are required to use E-Verify just as the general contractor is. And then it helps if we clarify in the law who gets the affidavit that is required. There's a form affidavit on the Department of Labor's website that these companies fill out, and they pass them along to the state agency, and so this language clarifies how that process works. There is a problem, a big gap in the current law, if a subcontractor or any subcontractor does not use E-Verify because they do not have employees, but they hire independent contractors. And so the sub could get around the requirement by saying they don't hire employees and they hire independent contractors, and therefore they don't have to E-Verify. So this language would require some form of identification, a state driver's license or state ID, to be presented by the independent contractors to replace the E-Verify requirement, and we believe that closes a big loophole in the current law. There are also reporting requirements that are currently in law, and this just further clarifies that the state agent or the local agencies and the state agencies have to keep these affidavits, and the local agencies have to send compliance reports to the state auditor. And so that's a general description of that part of the bill. Section 4 basically mirrors federal law that creates a higher level of offense and penalty for identity fraud when it's used to obtain employment. So if you present fake documents when you're applying for employment, which you're required to present under the I-9 requirement, federal law now creates a crime and penalty for that, and this state law just heightens the penalty for presenting fake documents in the I-9 process. Section 7 is language that was at issue in Arizona, and so we wanted to look closely at it. So we looked at the Arizona case where the judge went through Arizona's statute, and in the process of going through that legislation, the federal court judge identified some areas that were okay, and she did not enjoin enforcement of those provisions, and then she nailed it down to what the problems were. And this language on transporting illegal aliens was found by the judge to be okay, mainly because it's already federal law and it just mirrors federal law and makes state law consistent with federal law. So that is Section 7. Another part of Section 7 is harboring. Again, it's the same description. The court there said the language was okay, She did not enjoin enforcement of that language because it's consistent with federal law. And the same thing about inducing and enticing. Section 8 is the area where the court did really drill down and get into some problems in the Arizona law. And so we have the benefit of knowing what that law is and how the court found that law to be deficient in some areas. And this is the traffic stop by local law enforcement. What the court said in that case, that the way the Arizona law was drafted was that it applied to all persons arrested, that law enforcement would have to verify the immigration status of all persons arrested. And that was found to be too broad of a standard. And so Representative Ramsey has tightened the language here and tried to address that legal issue, and we've looked at it to make sure that it does set some hurdles for a law enforcement officer. One is that the officer must have probable cause if to believe a suspect has committed a crime, and the suspect then is not able to provide certain identifying documents. Then the law enforcement officer, obviously his or her suspicion will be raised if these documents can't be provided. And so we believe that tightens it up and addresses some of the court's concerns that were raised over that issue. Section 9 is simply encouraging Georgia law enforcement officials to cooperate with federal authorities. The federal government actually encourages states to get involved in the enforcement of immigration laws, recognizing that illegal immigrants outnumber federal agents by 5,000 to 1, and that number is an old number, so it may be more skewed at this point. So obviously, noting that problem, the federal government encourages states to help in the enforcement of immigration laws. This language just is consistent with the federal requirement that local government, local law enforcement cooperate in the enforcement of immigration laws. There are some standards, federal laws about how that works, and all of this language says the state law must be consistent with the federal laws in that area. Section 10 is, again, encouraging state and local law enforcement to learn how to enforce immigration laws and train in that area so that they can cooperate with the federal government. Section 11, again, is encouraging local law enforcement and state law enforcement to use the 287G program, which is the main federal program that provides for cooperation between state and federal law enforcement officers and local law enforcement officers. Section 12 is a requirement that all businesses who are licensed by the state of Georgia under Title 43, and there's a list on the Secretary of State website who those businesses are, would be required to use E-Verify. The reason that in the Senate version we specified that it is a state licensed business that is required to use E-Verify is that the federal law is very clear that in the area of licensing, states can require verification of authority to work. The courts in some areas have said the federal government or the federal law preempts state law and states can't legislate in that area, but it seems very clear that states can legislate in the area of businesses that they license and put that requirement on those businesses.